A very interesting judgment, Ankur Kampani versus Union of India. In this judgment, the Honorable Punjab and Haryana High Court has decided that penalty orders be passed without prior notice caused for violating natural justice and Section 75, subsection 4 of the CGST Act. The summary, let us understand the summary in detail. A penalty of rupees 4 crores was imposed on the petitioner under the section 122, subsection 1, class A of the CGST Act and HGST Act and section 20 of the IGST Act without any period notice. The High Court quashed the page order holding it to be violation of the principles of the natural justice and section 75 subsection 4 of the CGST Act. The summary of the facts and the dispute. Impugned action. A penalty of 4 crores was imposed on the petitioner through an order dated 15 December 2025 under various sections of 122 of the CGST Act and HGST Act and Section 20 of the IGST Act. The petitioner argument The petitioner argued that no notice whatsoever was issued prior to the penalty order, rendering it violative of the principles of the natural justice and Section 75, subsection 4 of the CGST Act. The core question of law, whether a penalty order passed without issuing any prior notice to the petitioner is violative of the principles of the natural justice and Section 75, subsection 4 of the CGST Act. Key legal issues and findings: the violation of the natural justice and the procedural requirements. The court observed the mandatory procedural requirement for issuing a notice prior to imposing a penalty. Absence of notice. The impugned penalty order dated 15 December 2025 was issued without any prior notice to the petitioner. Violation of the natural justice. The lack of prior notice directly contravenes the fundamental principles of natural justice, which mandates an opportunity to be heard. Conflict with statutory provisions. The order also conflicts with the Section 75, subsection 4 of the CGST Act 2017, which implicitly requires a notice for proceedings involving determination of the tax, interest, or penalty. A very good judgment where the ruling was as follows. The infringed penalty order dated 15 December 2025 imposing a penalty of around 4 crores is cost the petitioner direction the penalty amount of 4 crores is deemed unenforceable against the petitioner. Liberty. The liberty is granted to the respondent to proceed afresh against the petitioner in accordance with the law. A very good judgment. If you have facing this issue, then it is better to approach the Honorable High Court and ensure that your order is quashed so that a fresh set of notices can be issued by the respondent, that is the department, and it will be heard by the department, and then the order shall be passed so that you get maximum relief and you can put across your points before any action is taken by the department. If you like this content, subscribe to the channel and hit the like button.